Welcome, everybody. This is the September Ad Law webinar, and today we're going to be talking about considerations for your data licensing arrangements. I'm happy to be with you. My name is AJ Armand Zottola. I'm chair of the IP practice or IT transactions practice here at Venable, and I also am part of our advertising law practice. And I'm joined by Channing Gatewood, who will also introduce herself later. Next slide, please. So we got a full presentation for you, and it's going to provide considerations or a framework for approaching, drafting, negotiating, revising your data licensing agreements. Today, we're going to kind of walk you through a process for thinking about those agreements, starting with the data licensing basics, data licensing in the advertising industry, and then some key considerations, which we have identified here as rationale, complexity, compliance. And then we'll finish with some best practices. If we have time, we'll also open the floor for questions. So if you have any questions you'd like to ask about the presentation as we go, we'll try to answer them at the end, but certainly please provide them to our webinar chat because we can certainly follow up later as well. Next slide, please.
Great. Well, hi, everyone. My name is Channing Gatewood. I'm an associate within our intellectual property transactions group and also do work in our advertising practice. So I'm going to start it off by just talking about what is a data licensing agreement. And we've outlined that definition here. A data license agreement is an agreement that grants one party, the licensee, permission to use the data of the other party, the licensor, and subject to certain restrictions. The restrictions may include factors such as the length of time that the licensee may use the data and for what purposes the licensee may use the data. And again, the licensor is the party that grants the other party permission to use the data, the licensee being the party that receives permission to use the data. Sometimes one party can be both a licensor and a licensee in the same agreement. So for example, an advertiser may solicit services from a data provider, but the data provider may also need certain information or data from the advertiser in order to fully carry out the services. So in that case, the advertiser, while a licensee in that it receives data from the data provider, is also functioning as a licensor in that it is providing its own data to the data provider. For our purposes today, we consider a licensor to be the party whose primary purpose is to provide data to the other party, even if the licensee also does share some data with that party. The next term we've described here is data, which can refer to one of two things. It can refer to one, raw information, which can take many different forms, such as an alphabetical list of text or a list of numbers, or data can refer to a unique arrangement of that raw information. In order to be licensed to another party, data generally must fall into bucket number 2, which is the unique arrangement of information, which would then qualify that data set for copyright protection. Since copyright law protects original works of authorship, data must be arranged in a creative way to qualify for copyright protection, and the raw underlying data itself is not sufficiently creative. This concept was addressed back in a 1991 case, Vice Publications, where the Supreme Court found that a party's listing of telephone numbers and addresses in ABC order was not sufficiently original and thus did not satisfy the standards for copyright protection. Most compilations will qualify for copyright protection, though, as long as the data was actively selected, actively organized, and arranged. So copyright protection gives an owner certain exclusive rights to the copyrighted asset, and those rights may then be licensed, such as by way of a data licensing agreement to another party. Data may also qualify, as we put on the screen, for trade secret protection if a couple of things. If one, the owner of the data has taken reasonable measures to keep the information secret, and two, if the information has independent economic value from not being generally known, not being readily ascertainable through proper means by another person who can draw economic value from the information's disclosure or use. That's a mouthful, but generally, the takeaway is that a trade secret is information that is valuable because it is a secret and is protected because of efforts that are made to maintain that secrecy. So if a data set meets the standard, it may qualify for trade secret protection and can then be licensed as a trade secret asset. If data does not qualify for any form of intellectual property protection, the license is arguably null because the licensor does not have any exclusive rights to the data to begin with. And as we said earlier, raw facts are not personal property, they're not protectable. And so raw facts, raw information may be copied by anyone unless there is an applicable law or principle that designates that information as property.
So data these days really drives the advertising industry. Whether or not everyone on this call is a part of the advertising world, specifically as an advertiser themselves, or just a client or a client of services of the advertising industry, data is a critical component of that world, and it really is the key driver of value. Advertisers are using information about their consumers for targeting purposes and for other reasons, and so data itself is highly valuable, and it can be sold or licensed according to the agreements in place. Our conversation today is going to kind of focus on all the practical implications of the data license agreement. It won't focus strictly on a number of the privacy concerns, which I'm sure a lot of you have, but really about the agreement itself. But we will touch upon both the proprietary aspects, which Channing has done, and then also some of the privacy compliance needs that you will have in today's world. Next slide, please. So as noted, we're going to kind of break down the license agreement into three pieces. The first of which is your rationale, the second complexity, and the third is compliance. We think it's important to break the agreement down this way because in all of your organizations, you're going to have different stakeholders. Some of them are legal, some of them are non. And it's important to think through these arrangements before you get to the documentation stage, because sometimes you may not have the leverage to negotiate or affect a lot of changes. So thinking through your licensing agreements like this will help break down the document and may lead to better selection of vendors or better scope of agreement or even better terms. But when we say rationale, what we mean is considering what are the reasons for entering into the data license or the data agreement itself. When we say complexity, what we're saying is what are the specifics of the agreement that need to be written into the contract, and those are going to vary by context. And finally, when we say compliance, wonder what conditions can the parties to the contract license or receive the data. And this is where you'll see a lot of the privacy concerns is on that last piece of compliance. Next slide, please. Consideration one, though, is rationale. And this is a part of the consideration phase where you can involve and should be involving members of your advertising team or your business teams to really ask the basic question of why are you either receiving or granting a license to data. And next slide, please. Before we go through some of the parameters of those considerations for rationale, we want to break down two basic types of data transactions. The first of which is, what is the difference between a data license and a data sale? We'll start first with sales, although most of our focus today will be on the license because they're a little bit more complicated. But there are certainly instances where you may be engaged in a sale or an acquisition of data. So what does a sale mean? Like other types of intangible property, it means that you're acquiring the whole right that is available to that intangible interest. In this case, it means transferring personal information, typically, or data from one party to another. This is for monetary or other types of consideration. So in many respects, this type of transaction is not like other purchase or sale documents, but because it's data, it tends to come with some other additional compliance needs. And because it's data, there tend to be fewer ancillary components to the deal if it's just built around data itself. So the data sale can sometimes be a quick transaction. And the other important element is when you're getting the data, there are some considerations whether or not you actually can use any data you receive, notwithstanding the consideration angle. And finally, data sales kind of relate to a concept of ownership, which is a proprietary term, but in many respects with data, particularly in the privacy world, the notion is more of one of a controller. Who is really controlling the data? It's not really ownership. And we use that term later, and that is the term used for purposes of privacy considerations. Turning then to the data license, data licenses are agreements that provide less rights than the whole of ownership. And so the licensor is maintaining control. These arrangements tend to be longer term. They present more opportunities for ongoing fees. So rather than a one-time transaction, which certainly can be structured to have a schedule of payments, licenses typically involve the ongoing payments to receive the data. Again, the relationship is ongoing, so there can and tend to be other compliance obligations, such as security, that go along with use or receipt of the data, and a number of conditions that need to be set forth in writing. So data licensing is definitely a little bit more complicated, but the bottom line distinction is, in one instance, you're giving up all rights available to you, and the other, you're controlling some of them. Next slide, please. So moving back to considerations of the rationale for why, there are a lot of different reasons for a data license, which you enumerated some of them here. The typical one in the advertising world is targeting advertising. We're using the data to target ads to specific groups or people. Other types of contexts you will typically encounter include research and analysis, enhancement of existing data, basic distribution arrangements, so you're sublicense the data to another party. Data can be frequently used to create a lot of products and services, particularly other types of data. And again, data is the driver of a lot of analysis. So there are a lot of different places where you're going to see these data licensing agreements, and your data license agreement may not often be called a data license agreement. It can be called a lot of other things, usually using words similar to some of the use cases we've named here. But you want to be thinking about the data licensing considerations we named today, notwithstanding the agreement's title, or whether the agreement includes a data license and maybe other types of contractual commitments as well. Next slide, please.
All right, so now going to some of the motivations that a licensee or a licensor may have when deciding to enter into one of these data license agreements. A licensor and a licensee will generally have different priorities when deciding if a data license makes sense for their business. A licensor will maintain more control over the arrangement, so the licensor should already have a use case in mind before promoting itself as a data licensor. The decision to license out data to another party should be sensible, should be in consideration of the licensor's business and its business model. A licensor should also think about what rights to the data and under what conditions it would be comfortable licensing out its data for another party to use. For example, a licensor may not want the data to be used in certain industries, or it may not want the data to be sub-licensed to other parties. So the licensor should clarify internally first the type of license it's comfortable granting before moving forward with the arrangement. The licensor will also want to narrow the scope of the data license and clarify its ownership rights or any other rights over the licensed data. So now focusing on the motivations of a licensor. One is profit. Not only can the licensor receive revenue from the licensee by way of royalties as consideration for the data, but the licensor may be able to earn a percentage of revenue from the licensee's sub-licensing or sales of any data based on the licensed data as well. And that is, of course, if the licensee is permitted to license the data to third parties in the agreement. Also, attaching a fee to the licensed data can help the licensor recoup any costs expended in collecting and organizing the data, costs spent conducting research, or other activities. This is assuming that a licensor would want to receive a fee for the data, but there are also some fee-free licensing mechanisms like open data licensing that a licensor can consider if it is comfortable making the data more widely available to users with fewer restrictions. Another motivation for entering into a data licensing agreement is brand visibility. The licensor may want to establish a reputation as a cutting-edge data source, the data source that is ideal for a potential licensee's research, ideal for ad targeting or other business purposes. And if the licensor requires a licensee to credit the licensor as the source of the data whenever it's used, this even further promotes the licensor's brand. Next is strategic relationships. Data license agreements may help a licensor tap into a variety of industries. which may then help the licensor diversify the type of data it collects. Larger, more diverse data sets might appeal to a licensor's potential clients and in turn lead to potential profits. And last for this list is control. Establishing a clear licensing scheme may reduce the likelihood that third parties try to infringe and use the licensor's data without authorization. If there's a clear, publicly available process by which licensees should access the data, that may decrease the tendency of that same potential licensee to try and access the data inappropriately. So now the licensee side. The licensee as the recipient will have different incentives. One is easy access. So by receiving a license, the licensee does not need to actually carry out the research and processes necessary to collect the data to begin with. So bringing in data via a licensing agreement may be more efficient, even if it's at a price. Another motivation may be to enhance the licensee's own data sets, which might also enhance its services and products. Next, we discuss revenue or profit from the licensor side in the previous slide, but the licensee may also, if it's permitted in the license agreement, be able to combine the licensed data with other data sets, with its own data sets, and then provide access to that data to the licensee's clients. So this option could be a motivation if providing data to clients in this way is one of the licensee's own service offerings. Another motivation is understanding consumer behavior. Receiving a license to use certain data, even just that data alone, may help the licensee analyze consumer or potential consumer behavior, which might then inform how the licensee develops future products, services, advertisements, or just a more general marketing strategy. Next is targeted advertising. We've touched on this before. A licensee may want to disseminate ads to consumers based on data trends that are revealed in the license data. And then last for this list is risk reduction, particularly from a compliance perspective. The licensor will likely have needed to comply with certain laws in order to collect the data at all, such as the licensor is needing to notify data subjects that the data was collected, notifying data subjects about why the data is being collected, how it will be used, etc. Now, the licensee will have its own obligations too, of course, but the licensor, as the collector or controller of the data, several of the data protection compliance obligations and liability stemming from those obligations, if they are violated, will fall more on the licensor instead of the licensee. And so that might be a motivation for a licensee to assume the licensee role as opposed to the licensor role.
Moving on to our final piece of the rationale consideration is probably the most critical. What kind of data or what types of data is being licensed or received? We've put up a box here. This is not exhaustive and not necessarily saying that all these types of data are commonly licensed or even should be licensed, but the scope of data being licensed today is extremely broad. Almost anything that represents information can be licensed. And when you're doing an agreement for a data license, you really need to understand critically what categories of data are being received or granted and what forms of data are being provided. The other key consideration is, where is this data coming from? Are you getting the data from the data source, or is the data licensor procuring the data from other sources? And then finally, for all these substantive categories, what level of data are you getting? Are these individual records or records about individuals? Are these aggregated records or aggregated information sources? So this is a key component that won't necessarily be reflected in the legal terms. This is something also that you typically on the legal side will need to ask your business teams about, but you really need to know what kind of data you have, because certain types of data will also have more compliance needs or regulation than others. And in the privacy world, individual records clearly have more privacy concerns to the extent they incorporate personal information than aggregated or anonymized data. So the type of data license will really add a lot of complexity or not to your data license. Next slide, please. Which brings us to our second consideration, which is complexity. So after you've identified the reason for entering into your data agreements, you have to start thinking about the mechanics of it. Breaking this down, it's sort of question of how much data is being shared, for how long, and for what purposes or uses are you granted. Next slide, please. To help us think about this, we've broken this down to what we're calling the 5 W's. So the who, what, when, where, why. Starting with the who. Who is the licensor? Who is the licensee? These seem like obvious questions, but your contracting parties are not always the licensor or the licensee. So you need to be considering who actually is granting the data rights and who is receiving them. This means that you could be dealing with a licensor that doesn't actually own the data. It also means you could be dealing with a licensor that's procuring the data from other places. On a licensee side, the recipient of the data may be someone else. The user of the data may be somebody else. And so the who is a really important question that can be easily answered, but it's still the first one you should probably start with. And when you're dealing with a contracting party, you also have to distinguish between who the actual recipient of the data file will be, or the data access. So to whom will the data be sent? Is it someone other than licensee? Are you dealing with employees or personnel? Will the personnel be categorized as full-time employees or as contractors? Who actually needs access? The security associated with this can also be critical. So just answering the basic question of who is really important, because as noted, the named party, the licensor, isn't always the critical party, the owner or the controller. And finally, the who needs to sort of evaluate whether or not the grant is even permissible. Can you make the license or sale transaction itself? Next slide, please.
Okay, so now the next W, the what. Both parties should think about what and how much data is being transferred and how will that data be specified in the agreement. It's not uncommon for the data to be described in an attachment to the agreement. Generally, the parties will need space beyond the body of the agreement to list or describe all of the licensed information. But even if the data is just generally specified in the agreement, the description of the data should be more particular, and should also specify how the data will be delivered. Another what is what theory of intellectual property protects the data? Is the data classified as a trade secret, as a copyright asset, as we discussed earlier? The permitted uses for the data should align with that answer. So for example, if the data is a trade secret asset, the licensee may be more limited in how it can use the data and to whom it can share the data with, since secrecy is fundamental to trade secret protection. Another what form of data is being licensed? Is the data a collection of business and customer records, payment history, financial records, analytical records, refined data that describes patterns and predicts behavior? Is it a collection of reports, visuals, recommendations? And once that's answered, in what format will the data be delivered? Flash drive, email documents, etc. All of these above are what's that should be either described in the agreement or determined prior to the agreement's execution. The next W is the when. What is the length of time or the term of the license agreement, and for how long will the license be in place? And in line with that, can the agreement be ended or terminated early? Generally, a licensee will prefer that the agreement be irrevocable or not terminable, because it may be disruptive to the licensee's operations if the licensee has truly integrated the data into its work, to then allow the licensor to revoke that license at will or subject to certain occurrences. The term of the license agreement, or the when, should align with the ultimate purpose, so the why, a different W of the agreement. An example, if the license data is intended to be used to enhance the licensee's products, enhance advertisements, or just overall business operations, that intended use may warrant a perpetual license, since the licensee will be using the data on an ongoing basis for its business. But on the other hand, if the data is tied to a specific event with a start and stop date, and where the data use can easily be stopped by the licensee, a shorter term may be appropriate. Regardless, the agreement may still allow either party to terminate the agreement when certain major events occur, such as a material breach of the agreement, a violation of the law, or a violation of confidentiality obligations. But these termination rights all play into the when of the agreement and should be specified to avoid any ambiguities. The next W, the where. Where is the data going? And this can point to other questions. Where is the data being delivered? Is it sent to a disk and then mailed to the licensee? Is it being made available on an online database? A link sent via email? Then where and how can the licensee store the data? Then where else can the data go? Where can the licensee send the data? Can it be sent to other parties, end users, customers? And then aligned with these questions, the party should also confirm the territory covered by the license agreement. Where else can the licensee send or use the data? Is it limited to within the United States, worldwide, or particular non-US countries? And the answer to this question might point to which privacy laws are applicable to the licensee's use of the data. So the agreement should answer these questions.
The final W is the why. Another way to think about this is that it's really the scope of the license grant. Why is the data being shared? What permissions or licenses are being granted? This can be a complicated question, and even if your agreement sort of states a general rationale or purpose, doesn't necessarily inform or provide enough detail in the grant itself. What are the permitted uses? And a general question in all these agreements is use only permissible, or will there be some need or right to modify, which we'll get into a little bit more. If you want to think about this in terms of copyright terms, your why also can inform different elements of copyrights. So this can be the ability to make derivative works of the data, which is another way of saying, can you modify the data? What distribution rights are going to be available? Can the data be publicly displayed? This is not common with a lot of data licenses, but still a consideration. And then the other rights that may or may not be appropriate, namely sublicense or distribution rights. In addition to what is permissible, there will be the need to define what is not permissible, what limits or restrictions exist. With a lot of data licenses, particularly for compliance needs, there will be articulated prohibitions on certain kind of conduct. The data can't be used for this. In a lot of advertising contexts, there are a lot of prohibitions on using data for credit reporting, employment, hiring decisions, etc. So you have to kind of work down through these. And we would always advocate for a detailed data license. We feel that that will help both the licensor and the licensee. Shorter grants tend to be vague or ambiguous, and they can be harder to understand later if there is disputes. The license grant also will serve to inform any responsibilities that need to be allocated between the parties. So this license grant is a really important part of the agreement and one that really deserves a little bit more time. The next slide, please. So we'll break it down with some additional considerations related to the grant. In other words, what is permissible and what is impermissible. Data modifications. Can the data be modified at all, and in what respect? Modification as it relates to data is a little bit of a complicated concept these days. As noted, data in of itself isn't always copyrightable, meaning it isn't always considered a creative work of authorship entitled to copyright protection in of itself. So you can't really think about the term modification as equating to creation of derivative work. Practically speaking, modification means any change, and change can mean a lot of things. It can mean correction, it can mean updating, it can mean enhancements. And so whether or not the data can be modified is really a key aspect of the grant that you need to work through. And this will ultimately lead to questions of ownership. We will simply state for now that, generally speaking, rights will inure to the entity that creates, much like they do in the copyright space, where the author is deemed the owner, subject obviously to underlying copyright rights. But with factual records is a little bit more complicated. And so it's better to try and work through these aspects of the agreement now. And also appreciate again that if you're talking about personal information, well, nobody really owns name, address, etc. You're the controller of that information, but you're not really the owner. So if you have a record and you're adding a mobile number to an existing home number, you have changed the record. It has been modified, which is something that you need to account for in your license grant. But that doesn't necessarily mean that the original owner has any continuing rights to information, nor does it necessarily mean as the controller you've created any proprietary rights. But if it's new data, you probably are able to argue that you're still the controller of the new data. Then you need to think a little bit about whether or not you have the ability to transfer the data. Physically, what form does the data take? Electronically, how are you conveying the data? You're providing access through cloud storage? Are you providing a copy? In the old days, everything came in files. That's not really how things happen. But the method of transfer is also something you're going to want to work through. We'll talk a little bit about mentioning breach here, simply because the amount of control you extend in the license grant can also drive whether or not there'll be corresponding responsibilities for loss or breach. And it's important to appreciate that sometimes the licensee is going to have to take these on, even if the controller still maintains some responsibility for the loss as well. AI is related now to this topic simply because of how the data is used to inform or train AI tools itself. And so how data is being used in AI models is a key consideration for your AI agreements, even though that's not technically a data license. Functionally, it's frequently serving that role. Whether or not data can leave the United States. So data is intangible. What do we mean by that? Usually it means where the physical server storing the data resides. Is it in the United States or is it elsewhere? There can be limits on this, and there certainly can be laws that attach if the data resides in a legal jurisdiction outside the United States. And we noted that you need to know who your licensee is to assess whether there's any need to account for distribution. And then finally, what obligations are there when the agreement ends? You want to work through whether there's a need to destroy records, to return records, although that's sometimes complicated. You need to account for what continuing rights may need to exist because data frequently is ingested in the other sources. You need to account again for what happens to the modifications that have been made. Who owns those? Can you still use the underlying right? I noted that that's a complicated question, so I wouldn't say that there's any industry standards there. And frequently, you will encounter data licensors that wish to maintain heavy-handed control over how data can be used, even when there isn't a proprietary right supporting that level of control. At the same time, as a licensee, if you begin to assert rights as you're an owner or controller, you're going to be taking on some of the corresponding compliance obligations. So there's a bit of a balance here. It's something to work through, but the data grant itself is a really important piece of the license, and one we would advocate that you break down as we have. Next slide, please.
So next, we're going to discuss some compliance considerations. So looking to the question of, can you license in or out data, the data that you want to license, and subject to what conditions? Earlier, we discussed the data license and a data sale from an IP perspective, but now we want to touch on just lightly those two terms from a privacy compliance perspective. So from a privacy perspective, a sale is, and this is a general definition, which may vary by state, but a sale generally is any disclosure of data to a third party such that the third party may use the data for its own benefit. With that definition in mind, an intellectual property license may be a sale under applicable privacy laws. So from a privacy perspective, a sale can occur regardless, generally, of whether the data is sold or licensed to the recipient. So the sale or license distinction, while very important, of course, from an IP and contractual perspective, may not be as significant in determining if a seller or licensor of data will need to comply with certain privacy laws. So regardless of whether the data is sold or licensed, again, from the IP perspective, the seller/licensor would need to still assess whether or not the data is being sold as that term is defined in the applicable privacy law. For example, in California, the term sell includes selling, renting, releasing, disclosing, disseminating, making available, transferring, or communicating orally, in writing, by electronic or other means, a consumer's personal information to a third party for monetary or other valuable consideration. Considering that definition, a license then could arguably fall within this definition. And if so, there would then be certain contractual terms that would need to be executed between the data seller or licensor and the recipient, specifying how the data will be used or other specifications outlined in California's privacy law. So for today's purposes and as a takeaway, either a sale or a license may require compliance obligations, and the parties would ultimately need to review the applicable state law to determine if a sale covers the specific nature of the data transfer, and then determine the parties' obligations in line with that understanding.
So we want to dig a little deeper in some of the terms you're going to see in these agreements, or you may see associated with these type of licenses. But before I go further, I want to share the CLE code. The CLE code today for this presentation is Licensing 2024. Again, that's Licensing 2024. So in addition to understanding the word sale or transfer, there are some other terms you should probably appreciate, whether or not they actually show up in your agreement. And I'll talk about them here. These terms, unfortunately, vary. They vary by country and they vary within the United States. So we don't have uniform definitions for you. We've attempted to provide what generally is accepted or understood for each of these terms. We'll start first with controller. And the controller is the individual entity that determines the purpose or means of processing personal data. That's the term. You can think of it as the owner, although technically controllers don't actually own the data. The controller really is the entity that has the responsibility for the data. That's how privacy laws will look. The controller should anticipate carrying the same obligations that are going to be imposed by whatever applicable state laws apply. And if you're not otherwise aware, there are an increasing number of privacy laws that attach to the controller of the data, particularly in sale or licensing contexts. The term controller is not universally used, but there are equivalent terms. In California, they use the term business to mean the controller, and the term service provider to mean the next term, which is the processor. This is the individual entity that processes the personal data. This can be done on its own behalf, is done on behalf of the controller. What does process mean? It means a lot of things. It can mean collection, it can mean use, it can mean storage, it can mean analysis, it can mean modification. The processing role usually is a service role. And so when you're thinking about who the processor is, it's usually in the context of an agreement where the contracting party is performing something on behalf of the controller. You might be asking yourself, well, what if the agreement is sort of licensing the rights of the controller, so to speak, to another party? Well, you can have context where a controller, in effect, sort of creates another controller role. So you have to kind of look at the role being played by each party and whether or not the contracting parties are taking on the controller responsibilities or the processor responsibilities. And with a data license, you can have different kind of frameworks. You can have a controller processor license that's a simple service contract. Then you can have other contexts where each party may have a controller role. So certain obligations will be made mutual. And you can have another context where each party can be both the controller and the processor. This is frequent when you have data agreements where data is going for one party and the other party is providing data back. And so these terms don't apply simply to one-way unilateral data licenses. They can apply in a lot of different contexts. And frequently, they're applying to personal information licenses. So it means agreements that have personal information being granted licensed from one party to another. But you will also find these terms showing up on other types of data licenses, particularly because they have been commonly understood to mean these things and that these terms can work with other types of data. So a controller can be theoretically a controller of data that isn't personal data. But more commonly, in terms of how they equate back or correspond back to laws, controller and processor are the terms used to define the various parties to this agreement. Next slide, please. As Channing noted, there can be laws that attach to data transfers, and there are also limits. Currently, and this is changing by the day, there are about 17 states that limit or will be limiting how and whether one party can license, in other words, transfer in and out data of particular type of its state residence to another. And so when you're seeing a data license that involves personal data, you need to be thinking about whether or not there is even a limit or the ability to receive the data at all. This means you're going to have to be thinking about where the data is coming from, which state residence, where is the transaction occurring, whether or not that state law applies. But to make you aware of some of the limits you have, we'll go through a couple because the states all vary. For Connecticut, controllers must establish appropriate data security practices. So this means that the controller under law has certain data responsibilities. And to the extent that the recipient of data is sort of taking on controller-like responsibilities as well, this means that entity has to have those data security practices in place. Unfortunately, you cannot contract away some of these responsibilities, which means in a data license, you can't just say, I'm no longer the controller. You will always be the controller until you make a sale. So when you're evaluating the sale or the licensing context, in most cases, you're going to be looking at a license. Your controller responsibilities sort of still maintain, notwithstanding the license that you've entered into, which means you have to sort of allocate and manage your licensee to take on these responsibilities as well. Another responsibility that is common, particularly from the advertising space, is noted data subjects. So we use California as an example. Businesses, that's again the controller, must notify consumers whose data is being used, shared, or sold. In Florida, by contrast, the business must notify data subjects that data may be sold. That's an important distinguish, not will be, but may be sold. And so this also brings with it additional data management responsibilities to understand who needs to be contacted and whether or not you're dealing with data of an individual record. It's because of this that a lot of agreements are structured to avoid even using personal data. So you can sort of fall outside the scope of these laws so that you're not actually using anything that triggers some of these responsibilities. But at the end of the day, you might need the personal information, which means these responsibilities are unavoidable. Next slide, please. Continuing with other types of state data transfer requirements, there is a need in Colorado for a risk assessment. This is an AI-related issue as well in Colorado. So a business cannot process data in a way that risks harm to the consumer without conducting a data protection assessment. This assessment activity is probably going to expand not just from data protection, but also into algorithms or evaluations where data is being used to determine particular outcomes. And so the need to assess risk of harm is something that is more of an IT function, but also a consideration that will need to be made a part of your data agreements. There are several states moving on that have opt-out rights. You have to provide a mechanism to enable subjects to opt out of certain uses of their data. And this means that in certain cases, they may not allow the data to even be shared. And so your body of data records may be fluid. It may change. Your agreement may need to account for the fact that you're not necessarily providing a static amount of information, but one that may be altered in order to comply with state law, or in particular opt-out rights. And in addition, this is also creating outside the agreement, as we noted, these obligations to comply with state laws, which means that in addition to security, or maybe perhaps having a means to conduct a data risk assessment, you're going to have a mechanism in place to have opt-out. Now, the good news is that for a lot of your organizations, you've been doing this already for things like text messaging. So some of the protocols you may already have in place may be adaptable here, but the bottom line is even if your agreement doesn't account for these things, these state laws still apply. And then finally, as we noted earlier, there can be a lot of restrictions from these state laws on the types of data that can be shared or shared for specific reasons. Chief among them is children. Usually it's under the age of 13, but it can be higher, 16. The use of the data, a common one is data deemed for commercial use, is data intended for targeting ads or sales. And also certain types of data are deemed more sensitive than others. And financial information or healthcare information, as you will probably all know, is a type of sensitive data that carry additional compliance needs brought on by other laws such as HIPAA, Gramm-Leach-Bliley. And so these restrictions still apply to your data licenses. And you may see agreements that deal with data that have nothing to do with those types of sensitive data categories, but you still might see within the agreement these types of restrictions. And sometimes using these limits or restrictions is an important way to convey that you're providing data that won't fit into these categories. So the restriction portion of your agreement is just as important sometimes as the permission portion. Next slide, please.
All right, so considering the trends that AJ just walked through, it's good practice for a company to, before entering into a data sale or license, to keep these trends front of mind, even if they're not currently required by the applicable state law, because as AJ said, states are gradually enacting statutes that limit how data is transferred, how it's processed. So even looking to trends from current statutes might predict what restrictions will eventually apply to a data transfer, even if that transfer is not yet subject to an existing law. Kind of going through what we've touched on already, data subjects have rights. Consumers are generally given rights concerning the right to access their data, rights to delete, data portability, data correction, and opt-out rights as it pertains to certain transfers of their data or use of their data in certain ways. Another trend is the requirement to give notice and receive consent from data subjects before licensing out their data. Several states require this, and also parties entering into a data license should also review the state definition of notice to ensure that the party's understanding of notice is in alignment with and in compliance with the state law's definition. Both parties to the agreement should establish a practice of maintaining and keeping records of reasonable data security practices that they have in place, because generally controllers must maintain reasonable data security practices and processors are expected to assist the controller in securing the personal information by maintaining their own security systems. So keeping a record of these practices as well may be useful if either party is audited for compliance. Data controllers are also generally limited in the data that can be collected. Again, it's good practice for a company to identify what data, what categories of data are being transferred in the license agreement to then determine what other restrictions, possibly what other laws apply to how that very particular type of data is handled. Another trend is the opportunity to cure. Parties generally do have opportunities to cure any potential privacy law violations, but that right is often limited to a specified number of days. So while there might be an opportunity to correct any compliance issues, including some of the compliance topics that we've discussed today, that opportunity is not necessarily endless. So the parties should be aware of that limitation. States tend to detail how data controllers must respond to consumer requests about their personal information. So the controller in the arrangement should ensure that it has the systems in place and also that it has the people and certain individuals designated to handle consumer requests in accordance with state requirements. Generally, state law restrictions on data sharing do not apply or not as heavily when the data sharing is via merger, acquisition, or a similar transaction. And then the last trend for this list is limitations on data collection from minors. Essentially, all states have some sort of limitation on collection or processing of data for minors under a certain age. So thinking through those trends and also in thinking about the emerging technology, raising ongoing privacy and compliance questions, a data licensing agreement should prepare for a potential change in the law, which could upend the entire arrangement. Because new statutes concerning how data is used, where it can come from, are likely to keep coming. And this is where legal counsel can assist with drafting language to prepare for possible changes in law and can help with counseling on how to ensure compliance with these evolving statutes.
We're going to close with some logistics in terms of compliance. We're going to emphasize that licensees should make sure they have the means to comply with the data license obligations. They often forget that some of these obligations entail a number of additional measures at the company that go beyond just simple legal fulfillment. But at the same time, I want to emphasize that licensor, notwithstanding a license or granting a permission to another entity, still maintains a lot of its compliance needs as well. So both sides need to be thinking about compliance. There is a need for both sides to be thinking about their security commitments. Frequently, if the data is sensitive, both parties are going to have the same level of commitment because the licensor, the controller, has to ensure that the processor is abiding by the same levels of control. Security obligations are frequently in IT or very an IT function, and typically include penetration testing, maintenance of passwords or security protocols, maintenance of restricted access. There are certifications that will mandate certain approaches, but there isn't a one-size-fits-all. At the same time, you can't ignore these requirements. The other aspect of this is that auditing is a possibility, and this includes not just perhaps auditing of use, but auditing of related policies. So if an agreement includes a security commitment, then maybe you need to share a copy of a policy accounting for your security. And so you need to have the means to fulfill that. Next slide, please. All right, we're running up in the end, and we're going to tick off some best practices and see if we can get to some questions. So next slide, Channing. But to recap, and we've covered quite a bit, when you're thinking about your data agreements, well, first consider basically, is it this, is a sale or a license? But then think about whether, if a sale is even possible, if that's preferable to a license. And that may not be possible, but if it is, and if it is a sale, remember you're taking you're taking on the control responsibilities. But if it's a license, then you want to be thinking about the applicable IP protection, identify your rationale, your whys, the who, what, when, draft accordingly. If your license grant is not detailed in this respect, we're going to emphasize that you should expand here. You need to think about where the data is coming from and about what subject matter and what subjects. So what state and federal laws may apply. If you were in other countries, then you need to be prepared for compliance in those regions or jurisdictions. The key one is the EU, which is vastly different laws that are more protective of the United States. And frequently, they're going to drive compliance more than in the US if you're operating in both places. We would emphasize you stay abreast of data protection and privacy laws, and now also AI, as that's related quite a bit to this topic area. You need to assess your security protocols to be compliant here. Do you have data management? Do you have data security? Do you have policies for these things? And finally, set boundaries or limits so that you can control the data, because a lot of these agreements, as we noted, are going to have controls. Next slide.
Right, and lastly, in addition to those best practices, council can also help and ensure that common, what we call boilerplate language, is included in the agreement, which boilerplate is a collection of standard provisions included in a commercial contract, but which are not as related to the data license. They may not address data as pointedly, but still included just to maintain order and assign liability to the parties for certain occurrences. The list on the screen is not exhaustive, but just to include some, the provisions may include a definitions section to define, confirm the identities of the parties, identify certain authorized users, define permitted uses, confidential information, or just other terms that are material to the agreement to remove any ambiguity surrounding the meanings of those words. The agreement should also include a confidentiality provision, which requires the parties to maintain a certain level of care when handling the data and when handling any other sensitive information that might be exchanged. That section might limit to whom confidential information can be disclosed, employees, government officials, contractors, and under what conditions. It might also require parties to comply with confidentiality obligations even after the end of the license term. Another section is indemnification. This section assigns liability to either party in the event of a harm or a loss caused by certain events. This section can be particularly important where data is involved because, for example, if the licensed data is found to have been collected in violation of a certain law, then the licensee would want the licensor to be responsible as the collector of the data, even though the licensee is using the data. Another section is representations and warranties. This section involves an assertion of fact, a representation, and a promise that the representation is true, given by one party to the other. If proven false, that can constitute a material breach of the agreement. In the context of a data license, this section will likely include promises about the data. So a representation that the licensor has necessary rights to grant the license, a representation that the data will not infringe on a third party's rights, etc. A smaller section, but still important, is the notices section. This clarifies how the parties will communicate with each other. For example, where to send messages in the event of a breach, proposed amendments, or other necessary communication. So there's clarity about how those messages will be received. And last for this list that we've provided is the governing law section. This just confirms what state law will govern interpretation of the agreement should any of its terms be contested in court. There are more. Again, this is not an exhaustive list, but we emphasize this just to say that a data license agreement is still ultimately a contract. So it should still include commercial terms to clarify each party's responsibilities, boundaries, potential liabilities when carrying out the agreement and carrying out certain obligations under the agreement, including the data focus obligations that we've discussed today.
All right, we've got a couple minutes left and we have several questions, so we're going to do our best to answer them as quickly as we can, but we provided our contact information here for those that have continuing questions. And as always, we'd love to help you with these questions or with your future agreements. But first of which is, are there any benefits to data licensing versus data sale? I will say that's sort of context specific. Sale events also are going to be less common, and whether or not the controller owner of the data even wants to enter into a sale. But if you are a licensor in the licensor role, a license tends to provide longer term benefits because, as noted, you're giving away less than the whole, and there's more opportunity to charge fees over a longer period of time rather than have a one-time event. Moving on, are there expanded liability obligations on the part of the controller for a data license agreement or arrangement? The answer is yes. You're not really the owner per se, although you're treated as much. And from the law's perspective, particularly state law, you're deemed responsible for the data. So unfortunately, even when you're licensing rights to your data away, you still maintain that responsibility, which means that your agreements must flow down any responsibilities that the state has passed down to you as the controller. So this is an important thing you need to make sure are in your agreements. All right. What are the key features of a data license agreement to determine the character of the income for U.S. tax purposes? A little bit outside the scope, but by and large, this is going to be driven by whether or not your agreement is one for services or one for data. Data obviously is going to have royalty income and associated tax on the royalties. But if you're really just charging for the service, you may have different treatment. Where does the line draw there? That's not really one we can answer very generally, but you're going to want to talk to your tax counsel. This is also going to vary by state. All right. If data is used to train custom AI, so the licensees can now regurgitate the data in response to inquiries, is considered a copy of the data in regards to obligation to destroy, delete copies of the data at the end of the agreement. I would say yes, it is considered a copy. Now, it's not necessarily a copy for copyright purposes because the data itself may not qualify as a creative work of authorship. But to the extent the AI itself is ingested the data, it has, in a sense, copied the data. And so you have issues whether or not the data needs to be later destroyed, as seems to be the question here. The problem with this is, depending on some of the data or AI tools you're working with, this may not be easy to achieve. And you may not necessarily be working under terms where there's any requirement to delete. The key way to handle this is to be mindful of what data is going to be made accessible, because certain AI arrangements, certain AI tools may not be appropriate. Can you talk more about the restrictions on data intended for use in targeted advertisements? Do the strict obligations go away if the data is collected anonymized? It's no longer PII. Are consent still necessary up front? Short answer is they can go away. These state laws apply to personal information as defined. Every state has a slightly different rule, although increasingly what is personal is growing. So it used to be more simple, name, address, etc. Now it can be different types of data, a collection of groups of data that can identify even a device. So what is personal is growing, but if it isn't personal data, then a lot of these obligations go away. The law just simply doesn't apply. The challenge, of course, is that your agreement may not be so specific, and you may be dealing with obligations that suggest or assume that everything is personal data when it isn't. So that begs the question of what kind of data are you getting and what kind of data is being licensed. And you got to start that early on in your analysis, because that will detail what kind of obligations you actually owe. And that is all the time we have, unfortunately. It was great to be with everybody today. We hoped you learned something. I know it covered a lot, but a recording of this will be made available, and we thank you for your time.
Thank you.